Good morning, everyone. We'll just allow about 2 minutes so other people can join us. So we'll start in about 2 minutes. Thank you. Okay, I think it's a good time to start. Other people will join, in the course of the session. Uh, Good morning again. I hope you had a rewarding time yesterday. For those that were able to attend the two sessions yesterday, today we will be having another two sessions, starting with understanding international arbitration. And we have the pleasure of uh, an excellent speaker and one of the ACE arbitrator that we have from Ghana to take us through the journey of arbitration this morning. Her name is Nania Owusu-Ankomah. She's a litigation and arbitration practitioner and a partner at Echil Letsa and Akuma, a first-tier law firm in Ghana. She regularly advises and represents clients in a range of high-value litigation and arbitration disputes, including construction disputes, and is particularly noted for her innovative approach to solving complex legal issues. Naya sits as an arbitrator and has served as a member of the Electronic Communications Tribunal of Ghana, a quasi-judicial body with a three-member panel that hears uh, appeals in respect of the regulation and licensing of telecommunications companies, televisions and radio stations, and internet service providers in Ghana. Naya is dual qualified, called to the bar in England and Wales and in Ghana. She has a first class bachelor's degree in political science and philosophy from the University of Ghana. She has an LLM and qualifying law degree from the University of Leeds, where she won the Ford and Warren Prize as the most meritorious LLM student. Uh, Naya also is an alumna of the International Lawyers for Africa flagship program, through which she undertook a 3 month secondment program with the International Arbitration Practice at Organ Levels in London. Um, Naya, thank you for joining the session today, and you may now have the floor.
Good morning, everyone. Thank you so much for joining this session. Please permit me to share my screen with you. Today we'll be talking about arbitration, trying to get an understanding of arbitration. Before we move ahead, I would like to know if you can show in the comment box, perhaps, how many of you know or have had experience with arbitration. If you have, just type yes in the Q&A box. Okay, I don't see anything in the Q&A box, so it means we are all fresh here to learn about arbitration. That means that we are going to take it very slow, and we will do the basics and make sure that we are covering everything. Now, let's start with what arbitration is. We will have that discussion in a number of ways or in a number of stages. Firstly, we will go through an introduction to arbitration so we all understand what arbitration is. We'll talk about the arbitration agreement. We will look at the arbitration tribunal. We'll look at the arbitration procedures and proceedings, the arbitral award, how an arbitral award is enforced, and how an arbitral award is set aside or annulled. So let's start. What is arbitration? Now, I'm sure most of us are aware of what litigation is. Litigation essentially is that when you have a problem, a dispute with someone, you file your case in court, a judge is appointed by the court, and the judge hears the case and makes a decision. Arbitration is very similar to litigation. Arbitration is private litigation. So instead of having to go to a court, which is a public forum, to have the dispute decided, you go to a private individual who will then hear the case and then make a decision. So arbitration essentially is a consensual process where the parties in dispute agree to refer that dispute to an independent third party for the party to decide the dispute. The arbitrator's decision is final and binding. From this definition, there are 5 things we can glean from what an arbitration is. Firstly, arbitration is a private dispute resolution mechanism. This means that it is a way in which we solve our disputes privately. Rather than going to the court, we do that privately. 2, arbitration is hinged on agreement. The parties must agree that they want to use arbitration to resolve their dispute. Without an agreement between the parties, you cannot have arbitration. The agreement between the parties must be that they want to submit the dispute to an independent third party. Then that independent third party renders a decision on the case, which is called an arbitral award. When you go to court, the judge hears the case and gives you a judgment. When you go for arbitration, the arbitrators, who the parties also choose to handle the dispute, will make a decision, which is called an arbitral award, after hearing the case and making a decision on who wins or who loses, who is entitled to this and who is entitled to that. And that decision, importantly, is final and binding on parties. So now I know there's a bit of a confusion between what arbitration really is and what litigation really is. I've spoken to people who think that arbitration is just parties going to sit somewhere, having a conversation, having a third person try and hear the case and determine it, like a very friendly kind of thing. That isn't really what arbitration is. Arbitration, yes, is less formal than court. You won't have a judge wearing his wig and his gown. You will have an arbitrator dressed normally, probably in a suit and tie. In court, you will have lawyers there wearing their wig and gown, presenting their case. At arbitration, yes, lawyers are also there representing their parties. They are dressed normally. When you go to court, you see that the judge is seated at, on a higher level, looking down on everyone, listening to what everyone is saying. Usually at arbitration, you just have some desks. Yes, the arbitrators are separated from the parties, but the setting certainly is not as formal as the court. And most importantly, people think that arbitration does not take into account rules. Arbitration takes into account rules, except that the rules are rules that are agreed on by the parties. So let's take a quick look at arbitration versus court proceedings, because I think when we contrast arbitration and court proceedings, it will help us understand it better. Now, arbitration is private, whilst court proceedings are public. In arbitration, if you are not a party to the arbitration agreement, you cannot attend the arbitration proceedings or play a part in the arbitration, unless, of course, you are working with the panel. You are taking notes for the panel. You are a duly appointed official. But apart from that, unlike court where the courtrooms are open and anyone at all can enter and sit there to listen to what the court is doing, arbitration proceedings are not like that. You'll all recall recently that the Supreme Court broadcasted the election petition. Arbitration proceedings are not like that. It is a closed and private process, only belonging to those who are parties to their arbitration agreement. Now, litigation proceedings are in open court. Whatever is said, everyone can hear. Arbitration proceedings are behind closed doors. It's only the people who are involved and their lawyers and their witnesses who are allowed to participate. Now, an important thing about arbitration, which I think we all need to think about closely as an advantage, is that in arbitration, you are involved, the party is involved in selecting the person who is going to hear the arbitration case or determine the arbitration matter. Unlike court, when you file an action, you have no control over the judge who is appointed to sit and hear your case. All that you will be told is that your case is before Commercial Court 2 or Commercial Court 1. You go there, you see who the judge is, the judge deals with the case. Arbitration, there's an element of involvement because the parties have to select either the sole arbitrator or the arbitral tribunal. Sometimes the parties also agree for someone else to be the one appointing the arbitrator. So however it goes, there is some level of involvement in choosing who will decide the disputes. And that's very important because who is deciding the dispute, their background, their expertise, their knowledge will make a lot of difference in the quality of decision you get from them, or will determine whether they will even understand the type of disputes that is before them. Now, in arbitration, the parties agree on the rules that will apply to determine the dispute. The parties will agree on the rules. If you go to court, you have no involvement or a decision about what rules should apply to you. If you go to the High Court right now and you file a case, no matter who you are, the High Court civil procedure rules will be the rules that the judge will use to determine your case. The civil procedure rules will determine the timelines within which you are supposed to file, how the evidence is supposed to be presented. All of that will be in the rules. With arbitration, you get to choose or you get to participate in the choice of the rules. Now, there's something else about arbitration, which is confidentiality. In court proceedings, because it's public, there is no duty on the parties not to disclose what is going on in court. But with an arbitration proceeding, there is usually a duty of confidentiality, and especially where the parties sign, where the arbitrator will issue an order telling the party how the arbitration is going to go. There's usually a clause in that procedural order that says that the arbitration is confidential. So if you and I are having an arbitration, you are not allowed to go out and disclose what is happening in the arbitration or any information you get about me in the arbitration to third parties who are not involved. The same applies to the award. If we have an award, you are not allowed, the arbitrators are not allowed to share that award with parties other than the parties in the case. In courts, as soon as a judgment is given, anyone can apply for a copy of the judgment. You will even see it in newspaper reports where they have extracted parts of judgments and will put them in the newspaper report. However, in relation to arbitration, that is not the case. Publication of an arbitral award can only take place with the consent of the parties. Another very attractive thing about arbitration, if you compare it to court proceedings, are that enforcement is very wide, potentially wide in arbitration. If you go to court, enforcement of the judgment is restricted to the country in which the court is. A court's judgment from Ghana will be enforced in Ghana. An arbitration award has the possibility of being enforced in a number of jurisdictions, especially if the jurisdictions have all signed on to the New York Convention. The New York Convention allows arbitration awards that have been issued in a New York Convention state, that is a state or a country that has signed on to the New York Convention, that award can be taken to any other country that has also signed the New York Convention, and that award can be enforced in that country. So with arbitration awards, and especially with the New York Convention, it gives the arbitration award legs to travel all over the continent to be able to carry out enforcement. That is not the case with a judgment in a judgment in the court. Now, you may wonder, why is it even important for SMEs? Why is it important for you to know about arbitration or to prefer arbitration? Now, there's several advantages for SMEs. Number one, SMEs are growing, they are developing. They don't have time to be embroiled in long litigation in court. The good thing about arbitration is that it's time efficient. You are able to move faster. You realize if you've had a case in court that by the time you file and then it is served on the other party and the other party also files, and then there are times before you can even appear before the judge, and then the judge will also look at his schedule and the schedule of lawyers before they can get dates. It's a very long and arduous process that you must go through. And after that, there's the right of appeal. If you have a case in the High Court, you can appeal to the Court of Appeal if you are not happy. And if you are not happy with the decision at the Court of Appeal, you can go to the Supreme Court. So very easily, one case, you can spend 4 to 5 years in court. With arbitration, a good thing about it is that the arbitration award is not subject to appeal. It is not subject to appeal. So it is binding on the parties, unless, of course, you have grounds to set aside the arbitration award or annul the arbitration award, which is where there has been serious procedural errors. There have been serious errors committed by the arbitral award that may give you grounds to set it aside. Apart from that, you have no other recourse. So in respect of being able to go through the motions quickly and have a binding award, arbitration is preferable to litigation because you get a decision and that resolves the issue. As I already said, choosing an arbitrator is an important part, an important advantage for SMEs. This is because SMEs have various specialized businesses that they are involved in. Imagine if you are a high-tech company making software and you are involved in some form of intellectual property dispute with another company. If you are able to choose an arbitrator, you will definitely keep in mind, one, the arbitrator's knowledge of the business that you are in or of the field that you are in, so that he can understand the nuances of the case. If you go to court, you will get a judge, but you have no control over the level of the judge's knowledge about the area of your business. All you can do is do your best to explain it, but there is nothing else you can do with arbitration. By the choice of arbitrator you make, you are able to ensure that perhaps your position is understood better. That is another advantage. Another advantage, of course, is cost saving. If you're embroiled in litigation over 5 years, definitely you are spending a lot of money, not just time, but money in paying for legal fees, for filing applications and all of that. If you are able to get an arbitration award, even in a year, you have saved 4 years of hassle. And as I said, the potential of enforcement across various countries is also high. And privacy. which a lot of people do not think about. Privacy is important, particularly for SMEs, because they are a growing business. They may not want their dirty linen to be washed out in public, or there may be some trade secrets. There may be certain things certain modules that they are using to make sure that they are able to get win an edge over their competition, or they are able to deliver certain results. And if you are involved in a litigation where potentially that kind of information will come out, you may not be comfortable going for litigation unless, of course, you are taking very, very serious steps to file applications for the court to grant certain orders so that certain information is not disclosed. But with arbitration, because of the inherent privacy you have in arbitration, that is protected. So that's an important thing for SMEs to think about when they are deciding whether to choose to do arbitration or they would like to do litigation. Now, if we talk about arbitration, there are various types of arbitration. So let's go through that quickly. As I've said already, arbitration is where two or more parties decide that instead of the dispute going to be heard in court, they will have an independent third party hear the dispute and issue a binding decision. Now we have something that we have two types of arbitration. We have institutional arbitration and ad hoc arbitration. Now, an institutional arbitration is an arbitration that is administered or supervised by an arbitral institution. So just as you have a case and you will go to the High Court complex and you will file the case there, and then they will appoint the judge, and then you will go into the High Court complex, look for the relevant court to appear before the court. And the court has a registrar. It has a whole mechanism that ensures that your case is handled properly and expeditiously by the arbitrator. When you come to institutional arbitration, there are arbitral institutions that can have general oversight or administer the arbitration. And therefore, you have that kind of body that is supervising the arbitration, and you are able to file your documents there. They are able to arrange for you to have the proper framework within which to conduct your arbitration. So, for example, we have institutions like the Ghana Arbitration Center, the Ghana ADR Hub. We have institutions like the London Court of International Arbitration. We have the Lagos Chamber of Commerce International Arbitration Center. They are all institutional arbitration providers. So if you look at the example we have here, I've put an example of an arbitration clause. You will see that in the arbitration clause, it says that any disputes arising out of or relating to this contract or the breach shall be resolved by final and binding arbitration administered by the Ghana ADR Hub. Immediately you see that it's being administered by an institution, you know it's an institutional arbitration. When we come to ad hoc arbitration, that is simply an arbitration that is not administered by an institution. And so we will have, for example, a simple arbitration clause that is saying that it is the dispute is being resolved in accordance with the ancestral rules. Usually the ancestral rules, when you see that, then you realize that it is an ad hoc arbitration. No institution has been provided to oversee the arbitration. We also have international and domestic arbitration. Now, for an international arbitration, it is when the parties to the arbitration agreement reside in different countries or are of different nationalities. So for example, if I have a dispute with Abayomi, Abayomi is Nigerian, I am Ghanaian. In that case, when our dispute will be international in nature because we are of different nationalities. The arbitration transcends the national boundaries of Ghana or of Nigeria. He lives in Nigeria, in Lagos, I live in Accra. If we have a dispute, it will qualify as international. And of course, the more complex it is, the more easier that you are able to see how it transcends the national boundaries. There's domestic arbitration as well, which is where both parties are nationals of one state or country, or they all live in one country. So we have an example here. Sunset Company Limited, a business registered as a limited liability company in Ghana, enters into a contract with Mr. Osei, a financial consultant based in Ghana, to review the company's financial activities and provide professional advice. The consultancy contract signed between them contains an arbitration clause stating that any future disputes arising out of or in connection with the contract would be resolved by arbitration at the Ghana ADR hub under the Alternative Dispute Resolution Act. If you look at this scenario, you will see that both Sunset Company Limited and Mr. Osei are Ghanaian companies. Sorry, Sunset is a Ghanaian company. Mr. Osei is a Ghanaian. He's a Ghanaian national. So this would be a domestic arbitration. You will see that in the same arbitration clause, it provides for the Ghana ADR hub to be the particular institution that is charged with administering the arbitration. This makes it an institutional arbitration. Now, what is an arbitration agreement? An arbitration agreement is simply an agreement by two or more parties to submit all or certain disputes which have arisen between them in respect of a defined legal relationship, whether it is contractual or not. Now, from this definition, let's tease out the elements of an arbitration agreement. First of all, there must exist a legal relationship between the parties. You cannot have an arbitration agreement with someone you are not involved with in any you have no legal relationship with. So, for example, I will not be considered to have an arbitration agreement with a shop across the street if I have no business with that shop. But if I have some business to do with the shop, or I am their customer and they, for example, supply me some goods, then there is some form of legal relationship, some form of interaction. That is a formal relationship between us. That is the first thing that must exist. Then two, there has to be consent between the two parties that it is arbitration that they want to use to resolve their dispute. The third one is that the parties not only agree to arbitration, but they must agree that present and future disputes between them. It may be some disputes, it may be specific types of disputes, but the arbitration agreement will state whether it is all disputes or it is certain disputes. If you look at the definition here, you'll see that we say all or certain disputes. Now, another important element of an arbitration agreement is that there is an independent third party or private person to decide the dispute. Then the arbitration agreement would also indicate the scope of the disputes to be submitted to arbitration. Is it all disputes? Is it disputes in relation to breach of contract? Is it only disputes in relation to latent defects in a building. So the arbitration agreement will indicate the dispute, whether all or some, which should be referred. Now, another thing too that we must notice that the subject matter of the dispute must be arbitrable. And by saying that, we mean that the subject matter of the dispute must be capable of being resolved by arbitration. The subject matter of the dispute must be capable of being resolved by arbitration. Now, every country has the kind of disputes that can be resolved by arbitration and the kind of disputes that cannot be resolved by arbitration. So in Ghana, Section 1 of the ADR Act provides the instances where a particular type of case cannot be resolved by arbitration. Those matters are called non-arbitrable matters. So, for example, Section 1 says that if you have a dispute relating to an interpretation of the enforcement of the Constitution, you cannot go for arbitration. So if it is a constitutional right that you are trying to defend, even if the parties have an arbitration agreement between them, you cannot, that particular dispute will not be arbitrable. It is not capable of being resolved by arbitration. Again, matters relating to the enforcement of environmental issues, those matters cannot be resolved by arbitration. So you must also ensure that the kind of dispute that you have is capable of being subject to arbitration. The final thing is that the arbitration must be final. The award that the independent party issues must be final and binding. Now, as best practice, you need to, let's talk about what an arbitration clause is. An arbitration clause is simply an arbitration agreement that is situated within a contract. So if you have a contract with someone to supply you, let's say you have a contract for someone to supply you plastic for you to use in your business as an SME, you manufacture plastic chairs, and you have a supply agreement with another entity to supply you the plastic. In that agreement, if you put in an arbitration agreement, we call it an arbitration clause. It is a clause in the agreement indicating that this is what the parties are agreeing to be the preferred way in which they will resolve their disputes. Now, so I give an example here. If you say any disputes arising out of or in connection with this contract, which means that it is in a contract, including any question regarding its existence, validity, termination, shall be referred to and finally resolved by arbitration. The seat or place of arbitration shall be Accra, and the dispute shall be resolved in accordance with the Ghana ADR hub rules. This is an arbitration clause, and we want to tease out the best practice of what should be in an arbitration clause. And this is very important because in my practice, usually when SMEs are entering into contracts, they will only take a copy of the contract, review it themselves, and then sign. In fact, they don't even look at the arbitration clause, which is at the very end, usually at the very end of the contract. They only look at the terms and conditions, the monies that they have to pay, the time that they have to pay. I agree, and they sign without looking at the arbitration clause. The arbitration clause is very important because when there is a dispute, at the time you are signing the contract, everything is sunshine and rainbows. So you don't think anything can go wrong, but any relationship can go sour, and therefore particular attention must be paid to the arbitration clause. And these are some of the things that you should look out for in the arbitration clause. That number one, does the arbitration agreement provide that the parties have agreed to go for arbitration if there's a dispute? Does the arbitration agreement indicate the scope of the disputes to be submitted to arbitration? Does it tell you whether all disputes or certain kinds of disputes or certain categories of disputes? If you look at the example we have here, you will see that we say the arbitration clause says that any disputes arising out of or in connection with this contract, including any question regarding the contract's existence, validity, or termination, shall be referred to arbitration. In this case, it means that every conceivable type of dispute that arises in connection with this contract will be subject to arbitration. Now, the third thing you want to look at is whether it includes an arbitral institution or it includes the rules that should apply to the arbitration. As we said, it is not automatic that if you have an arbitration clause, it will require you for the arbitration to be administered by an institution. No. So if what you want is to have a body administering the arbitration, you need to ensure that that is included in the contract. The seat of the arbitration is a very, very important part of an arbitration agreement. If the arbitration agreement does not indicate the seat, then when the matter goes ultimately to arbitration, that will be a subject that the parties will have to address the arbitral tribunal on for the arbitral tribunal to make its decision. Now, what is the seat of the arbitration? The seat of the arbitration is the state or the jurisdiction where the arbitration derives its legal presence. So if you look at this arbitration agreement, it says that the seat or place of arbitration shall be Accra. The seat is not the same as the venue. The venue is where the arbitration proceedings will be heard or the arbitration proceedings will take place. That's the physical venue. But the seat is a legal concept. It is the place where the arbitration derives its authority. So what does the seat do, or why is the seat important? So now if you look at this arbitration clause, it says that the seat is Accra. This means that the ADR Act, which is the Local Arbitration Act, will have some application to the arbitration. It also means that the court that is empowered to provide support for the arbitration, if that is required, will be the courts in Accra or in Ghana. So, for example, you can have an arbitration agreement that has the seat as Accra, but then the arbitration proceedings will be held in Lagos. The arbitration proceedings will be held in Lagos. If there are any questions as to the applicability of an arbitration act, it will not be the Arbitration Act in Lagos, it will be the Ghana Arbitration, the Ghana ADR Act that will apply. If the parties who are conducting their hearings in Lagos, for example, want a court to provide support to the arbitration proceedings, they will have to apply to the Ghanaian courts, which is the court at the seat of the arbitration. So a seat is very important. And if you have an arbitration clause, you want to make sure that the seat is familiar. If it's a seat, like, for example, if you're a Ghanaian company and the seat is Paris or Uruguay, you do not know what the laws, the particular arbitration laws in Uruguay are. You don't know how it will apply to you. You don't know how the case law has developed, and therefore you will be working in blind. It is always better to choose a seat that you are familiar with. And one thing I need to emphasize is that although we are given these tips, this work must be done by a lawyer for you. I know SMEs always hesitate to appoint lawyers, but there are certain things that you are unable to do. You will need someone with legal expertise to be able to critically look at the clause and determine whether the clause will work out in your favor. Now, the next thing that you must look out for is the method of appointment of the arbitrator. How are the arbitrators going to be appointed? Is it going to be both parties agreeing on one arbitrator, or is it going to be each party choosing their own arbitrator and the two arbitrators chosen then agree on a third person to be the chairman of the arbitration? You also have to consider, do you want to include certain qualifications that the arbitrator must meet? You may, for example, if you are a serious IT company that is entering into a software agreement with another IT company, you may, for example, want to indicate that the arbitrator should be someone who has a background in maybe IT or software development or whatever it is. But you need to make sure that you are not too specific in your arbitration agreement, because as it is, if you write that, for example, you want an arbitrator who has 16 years experience in software development, you may never get someone like that. So you need to keep an open mind. The language of the arbitration too helps if it says that if you are from two different countries, for example, a Ghanaian company and a Czechoslovakian company, if you have that, you know that there is a language barrier and you haven't already agreed on the language in which it should be conducted, that may become difficult. Now, the choice of law that should be applied by the arbitral tribunal is also an important consideration. If you're a company SME in Ghana and there's an arbitration clause that is saying that the substantive law of Ukraine should be applied in determining the dispute, you're putting yourself in hot water because you don't know what the law is. You don't know what the legal provisions are. And if, for example, it is a supply agreement where your suppliers are in Ukraine and you are receiving the goods in Ghana, wouldn't it be better that the laws in Ghana would apply? Do you know the sale of goods, the law relating to sale of goods in Ukraine? No, you don't. So you want to look out for that and see if as much as possible you can negotiate it so that it is more familiar to you, or at least to the lawyers who will represent you. Now, we've said that you can have an arbitration clause and then you can have a submission agreement. So an arbitration clause is a clause within a contract that you want to submit future disputes arising to arbitration. With a submission clause, the dispute has already arisen. You did not have an arbitration agreement. The dispute has already arisen, and then you decide that, in fact, it would be better for us to go to arbitration. The fact that you didn't have an arbitration agreement in the first place does not mean that arbitration is closed to you. If the two parties can agree and put together an arbitration agreement after the dispute has arisen, then you can have an arbitration agreement after the fact. So a submission agreement is an agreement by parties to submit an existing dispute, that is a dispute that has already arisen between them, to arbitration. Now, the problem with submission agreements is that it happens when the dispute has already arisen, and it's very difficult for two disputing parties to see eye to eye. Things that ordinarily you would have agreed on, because you are in disputes and tensions have already risen, it's going to be difficult to now then belatedly agree on the terms of an arbitration clause. So the advice would be that as much as possible, try and have an arbitration clause at the very beginning in your contract, rather than thinking that, well, if we actually have a dispute, we can at that stage then agree to go to arbitration. You may never get that opportunity, or you may never be able to reach that understanding. So I give an example, for example, of a submission agreement, because this is something that I see a lot in SMEs. Initially, they never adverted their minds to arbitration, and then they realize the benefits of arbitration and they want to go for that. So in this example, we say that there are parties to a fintech contract who have a dispute resolution clause that allows them to go to court. Now, as a dispute subsequently arises relating to a defect in a novel software used on an electronic platform on which the fintech product will operate. The dispute is of a very technical nature, involving in-depth understanding of algorithms relating to the software in question, and must be resolved within 3 months to enable the purchasing party launch its novel fintech product. Now, the parties are concerned about the time it may take to resolve the issue in court, since a delay in the launch of the fintech product would greatly compound any damages claim and would no longer make the product competitive on the market. So the parties also worry that because the kind of dispute is very niche, it's in a very technical area relating to a novel software, which means it's a new software that does not exist. It has now come into existence, being operated on an electronic platform. They feel that they need a specialist who can understand the dispute properly to determine it. The parties therefore agree on a submission agreement after the dispute arises. So in that submission agreement, then the parties will specifically provide for an algorithm specialist, for instance, with 6 years knowledge or experience or whatever, to be able to resolve the dispute. At least with that, they are assured that the person making the decision will actually understand the case and be able to give a just decision. Now let's talk about the arbitral tribunal, which is very central to arbitration. As we've already said, an arbitral tribunal or an arbitrator is a private individual. This person is not a judge, it's a private individual who is appointed by the parties to resolve the dispute. Usually you have one arbitrator who sits as a sole arbitrator, or 3 arbitrators. Now, the competence of the arbitral tribunal is very important, because the arbitral tribunal is given certain powers. It's given certain powers, and the power is for the arbitral tribunal to rule on its own jurisdiction. So an arbitral tribunal can decide whether, for example, the dispute that has been brought before it comes under the arbitration agreement. It can decide whether the contract in which the arbitration agreement is valid. It can even decide if the arbitration agreement based on which he himself was appointed is a valid arbitration agreement. So the arbitrator has a lot of powers. Now, I just want to give an example to highlight what we mean by the competence of the arbitral tribunal to rule on its own jurisdiction. Thank you for the questions. We will try and address them as we go along, but I have specific time at the end dedicated for us looking at the answers to the questions. So this is the example. A bank has purchased 2 plots of prime land to build their head office. They engage a reputable construction firm to construct an 8-floor office complex for use as their head office. The construction contract signed by the parties includes a dispute resolution clause where they are first supposed to attempt settlement for 30 days. And then if that settlement does not work, then the CEO and the project manager of the 2 companies will then engage in mediation for another 30 days. The mediation must be facilitated by an engineer appointed by the Ghana Institute of Engineers. If the parties are unable to resolve the dispute after 10 days, then the dispute has to be referred to arbitration. The dispute arises between the parties in relation to the tiling of the 2nd and 3rd floors of the building. The bank refers the dispute to arbitration, and the ADR hub appoints a sole arbitrator. The contractor challenges the jurisdiction of the tribunal. So the factual scenario really is that there is an 8-floor complex. And under the arbitration agreement, certain types of disputes are supposed to be resolved by arbitration. If you look here, you will see that the first ground, sorry, please, let's go over the facts again. It's an 8-floor story complex that they are using as their head office. The construction contract includes an arbitration clause. And in the construction contract, it doesn't say that all disputes should be sent to arbitration. It says that disputes relating to, disputes relating to latent defects. So if the dispute does not relate to latent defects, then the arbitration clause does not cover it. And then they are supposed to refer it to the Ghana ADR hub for the ADR hub to appoint a sole arbitrator. Now, a dispute actually arises between the parties relating to the tiling of the 2nd and 3rd floors of the building. So it's not a latent defect. The bank refers the dispute to arbitration and proceeds itself to appoint a sole arbitrator. Now, the other party, the contractor, challenges the jurisdiction of the arbitral tribunal on 2 grounds. First, that the dispute does not relate to latent defects, and therefore it is not within the scope of the arbitration agreement. And second, that the arbitrator was not appointed by the Ghana ADR hub and therefore cannot hear the case. So in this case, we are saying that the arbitrator himself, who is even sitting on the matter, we are saying was not even properly appointed and he cannot hear the case. Now, by virtue of the competence of the arbitral tribunal, this challenge to the arbitral tribunal's jurisdiction will be heard by the arbitrator himself. So the arbitrator will have to decide whether the dispute indeed falls within the arbitration agreement and whether the appointed arbitrator, which is himself, can preside over the dispute. So after the arbitrator makes that decision, if the parties want or if the parties are unhappy, they can challenge this decision. But the thing is that, firstly, it must go to the arbitrator himself to decide. You know that unlike courts, when sometimes cases come before a judge, the judge won't, because it involves the judge himself, he will not be able to comment or decide on that himself. But with an arbitration tribunal, even questions relating to their own powers, they have power to rule on such matters. Now, let's go to arbitration procedure and proceedings. When we are talking about arbitration procedure, there are a number of frameworks within which the arbitration is conducted. Firstly, there's the substantive law of the arbitration, which is the law that the arbitrator must apply to decide the merits of the dispute. If you go to court and you have a case and your contract is governed by Ghanaian law, it is Ghanaian law that the courts will use to decide your case. If you have a contract that says that Ghanaian law must be decided and there's a dispute in Germany, that dispute, although it is happening in a different forum, is still governed by Ghanaian law, and it is Ghanaian law that must be applied to deciding the case. So we have the substantive law of the arbitration, which is the law that the arbitrators will apply to decide the case. And then we have the procedural rules of the arbitration, which also is the set of rules that the tribunal will use to determine how the arbitration proceedings are organized. So, for example, the procedural rules will, such as the Ghana ADR hub rules, or the rules of the Ghana Arbitration Center, or the ancestral rules, or the London Court of International Arbitration rules. These are all rules that will set out what the timelines are for the parties to file. You have 10 days after you are served with the claimant's case to file your response. That is determined by the procedural rules. And the procedural rules will also determine the procedure for the hearing of the arbitration. Now, the arbitration is not insular. There is still some kind of relationship between arbitration and the courts. So, for example, if you have an arbitration and you need the courts to issue an order to support the arbitration proceedings, the Ghana ADR Act allows the courts to intervene in specific circumstances to support arbitration. So, for example, if you have an arbitration agreement with your supplier, for example, and based on that arbitration agreement, you have commenced arbitration proceedings, but the issue that you are fighting over, for example, the goods that they supply to you that you are fighting over, that you sent back to them and rejected, they may still be in your possession or they may still be in their possession, because it is an important subject matter of the dispute. The court, on application by a party, that means the party will go and file something in court and ask the court, please come and support this arbitration proceedings. We are fighting over this drilling machine that they supplied to me. We need the court to preserve this drilling machine so that none of the parties interfere with the drilling machine whilst the dispute is being heard. That is something that a court can give to you. So can you imagine, for example, someone having had received goods, maybe a drilling machine, says that the goods does not conform to the specifications, or the good, there's a defect in the goods. the other party can ask the court to preserve it so that it's not like it's still in the person's property and the person's possession and the person is using it, or the person it's in the person's possession and the person can tamper with it to beef up their case. That is something that you can go to the court to ask the court to give you. Now we continue with our discussion on the arbitration procedure and proceedings, and we talk about how you go through the various stages of arbitration. Arbitration starts first by a party who is unhappy with something, filing a notice or sharing a notice indicating that they are commencing arbitration. If you were doing a court process, you would file a writ and a statement of case, a writ and a statement of claim. In the writ, you will put in the written statement of claim, you will tell your side of the story and ask the court to grant you certain orders against the other person. In much the same way, if you want to commence arbitration proceedings, you must put down the nature of your dispute in a document and then indicate the reliefs or the things that you are seeking from the arbitration in that same document. And that document is served on the other party. That is how the arbitration is commenced. So arbitration starts with one party filing a notice of commencement of the arbitration. Once that is done, the arbitral tribunal is composed. So you have the initiating document process that starts the arbitration process. Then the arbitral tribunal is composed. As I said before, you can have one arbitrator who is sitting as a sole arbitrator, or you have 3 arbitrators usually who will be appointed, one by each party and the third by the 2 appointed arbitrators. Once the arbitral tribunal is composed, then looking at the procedural rules, timelines are set for each party to file their statement of claim or statement of defense. That is the documents that the arbitral tribunal will be using to evaluate the various cases or grievances that have been brought before them and the responses to those grievances by the other side. Then you have a preliminary meeting where they will meet, the parties will meet with the arbitrator, and the arbitrator will set down the guidelines for the conduct of the arbitration. At the preliminary meeting, they may indicate the dates where they will have the hearing, the time where they will have the hearing, the venue where the hearings will be held. All these matters are agreed at the preliminary hearing. Parties will indicate which witnesses they will be calling, all of that. Discovery, usually, as the word suggests, it's finding out documents that are in the possession of the other party, which are required in the case. Usually with arbitration, when parties file their pleadings, they attach copies of the supporting documentation, or when they file their witness statements, which is the written evidence that they are going to give at the arbitration hearing, they usually attach all documents. But sometimes some parties choose to hide certain documents or not disclose certain documents, and provision is made for a party to ask the other party to discover, to bring out those documentation for the arbitral tribunal to use and for the other party to use if it is beneficial to them. Now, when we come to the hearing, it is not all the time that you have a physical meeting or a hearing. You can have an arbitration conducted on documents alone. You can have an arbitration conducted on documents alone in certain cases. So for example, if two parties are disputing about the interpretation of a contract, for example, two parties have a supply contract and they have agreed that you pay a first tranche of money once the agreement is signed. You pay a second tranche of money once the goods are supplied to you. And then you pay a third tranche of money after a number of days. If there's some dispute as to whether the agreement said that this particular time is the time that the payment should be made, that, for example, may not need a full hearing. So let me give you an example, a typical example. If you have a supplier who is supplying you goods and they are supposed to first of all supply you, first of all, you sign the contract, you pay some money. They supply you the goods, you pay some money. And then at the very last stage, maybe after a number of days, you pay the last tranche. Now you have ordered 10 things. They have supplied 9. You haven't received the 10th thing. Are you still required to pay the money when you haven't received the 10th thing? That can easily be a subject of dispute. And if it is merely a matter of interpreting the contract to say that, well, in this case, if you haven't received the 10th thing, then your obligation to pay has not yet arisen. You don't even need a full hearing for that. So the the arbitrator can look at the documents that are before him, read the contract, and then decide when that obligation arises, the obligation to pay. But you have circumstances where there are a lot of factual matters that are disputed between the parties. One party is saying this happened, the other party says no, the other thing happened. When there are a lot of factual misunderstandings, it's important for the court to hear both parties, to hear what their witnesses have to say, and then decide the dispute. And in that case, you have an oral hearing. And an oral hearing doesn't necessarily have to be physical. As you all know, with the COVID-19 era, we are having proceedings virtually. So virtual hearings are also part of the hearing stage. After all this happens and the matter has been heard, then they issue an arbitral award. The arbitral award, as we've already said, is binding on the parties. You only have very few, then you have only very few circumstances where you can challenge the arbitral award. But if the arbitral award is not challenged, then you go to enforcement, which is trying to give power or strength or derive the benefits that the arbitration agreement has given you. And that may include, for example, if the arbitral tribunal has ordered that the other party should pay money to you and the other party has not paid, you can actually enforce the award against them, attach their assets so that you can sell and get the money you have been awarded. Let's move on to talk about the arbitral award. These are pointers about the arbitral award. It has to be in writing, final and binding on the parties. It must be reasoned, so it has to state the reasons upon which the award is based. It must be signed by the arbitrators. It is only valid where it has been signed. If one of the arbitrators in a panel of 3 arbitrators doesn't sign, it has to state the reason why one person has not signed. The award must indicate the date on which the award was made. It must state the place where the award was made, which is the seat of the arbitration. So in the example that I gave, that I have a dispute with Abayomi, for example, and we are hearing the case in Lagos, but the seat of the arbitration as provided in the arbitration agreement is Accra. When the award is being delivered, the indication in the award will be that it is an award delivered in Accra. not the physical location where the hearings were held. And once it has been signed, dated, and the seat of arbitration or place of the arbitration indicated, then it has to be communicated to the parties. And as we've said already, the arbitrators are not allowed to make it public to others. They can only communicate their decision to the parties unless the parties have given their consent. Now, there are very limited circumstances where you can set aside an award. So I would say that when you are going in, have it in your mind that you are going to be bound by the arbitration, by the award, because it's only in few circumstances where the court will say that, in fact, this award is not a valid award or is not good enough and should be set aside. And in Ghana, for example, if you have a foreign arbitral award, that is an award that is seated not in Ghana, but somewhere else, the court will look at whether the award has been set aside at the seat. The court will consider whether the person whom the losing party was given sufficient notice of the arbitration proceedings to enable them present their case. They will look at whether the award deals with issues that were not submitted to arbitration. They will look at whether there was some incapacity. One of the parties had an incapacity, which would make the arbitral award unenforceable or will mean that it is unfair. Usually, when the court is looking at setting aside, they are looking at some form of procedural impropriety that happened during the arbitration. One party was not given an opportunity to be heard. One party was not given sufficient time to present their case. The arbitral tribunal was not composed in accordance with the way that the parties had agreed. The subject matter of the arbitration is not arbitrable. It is not that the kind of dispute is not one that can be settled by arbitration. These are the only grounds, and perhaps yes, these are the only grounds that if you have a foreign if you have an arbitral award, it can be set aside. The same applies to domestic arbitration. There are very few instances where the court will set aside an award. These have all been stated here. Now, when we come to enforcement of an arbitration award, remember, an arbitration award is not a judgment of the court. It is only a court that has that compelling mechanism behind it to be able to enforce an award. An arbitral tribunal cannot enforce an award because they are normal citizens, they are private citizens. So if you need a court to compel a party to satisfy their obligations under an arbitral award, then you would need to come to the court and ask for leave for the arbitral award to be enforced. So in Ghana, for example, if you have an arbitral award, and arbitral awards are enforced as judgments of the court. So technically, they are converted to become judgments of the court and then enforced as any other judgment of the court is enforced. So first of all, you have to apply for leave from the court to enforce the award as a judgment. The losing side, of course, will have the opportunity to respond to the application that you filed. The court will hear the application and then grant leave to enforce the judgment, the award, if it feels that there are just circumstances. Now, when it comes to enforcement of the award, the court is not now looking at the merits of the arbitrator's award. The court is not considering whether the arbitrator's reasoning is valid or not, or whether the arbitrator's finding that one person did this or the other person did that is valid. No, the court is not an appellate court that is reviewing the decision of the arbitral tribunal. It is simply ensuring that the award complies with certain requirements, and we have talked about some of them. Did the parties get enough notice about the proceedings? Were the parties given enough, were the parties heard, given time to present their case? Was there any form of bias on the part of the arbitrator? Was the arbitrator, for example, someone who had an interest in the matter but did not disclose this interest? These are the few circumstances where the court will not enforce the award, will not grant leave for the award to be enforced. But once the court grants leave, then the award essentially becomes a judgment of the court, and just like any other judgment of the court procedures are used to enforce. So, for example, if the arbitral award said that you are entitled to $5 million and the other side has not paid you the $5 million, if you come to the Ghanaian courts and you are given leave to enforce the award, you will file processes at the court's registry, and the bailiffs of the court will go and attach properties belonging to the person who is supposed to pay the 5 million under the arbitral award. And the whole court process works in such a way that you go through processes where these goods will then be sold for the sums of money you must be paid to be satisfied. So it's the normal court procedure that is used to actually realize the arbitration award. Now, there are some key points for SMEs. Why, we've already told you the advantages of choosing arbitration over litigation. But if you are choosing arbitration, you need to think about these points. Number one, you should have the arbitration clause in your contract. Have it on straight ahead. Don't wait. That will help you avoid protracted litigation. The arbitration clause should be properly drafted. And here I say, engage a lawyer. Don't try to do it on your own. You may not have all the necessary skills. Take care in who you choose to be the arbitrator in your matter. You need to think about the person's background, the person's knowledge, because a good arbitrator is more likely to reach a fair decision. You also need to ensure that you are putting your best foot forward in the arbitration, because as we said, arbitration is final and binding. You don't have any way of appealing unless there are limited circumstances where you can set aside the award. There isn't much you can do. And then also use arbitration with other forms of ADR to save costs. Remember, litigation is expensive, and being in court for a long time is not only going to cost you money, but it's also going to prevent your business from growing, because your attention is divided, and your expenditure and manpower is also going into trying to ensure that that case is being won. So these are the things that I would recommend for you to take account of if you decide to use arbitration to settle your dispute. Now, I'll invite questions, and I've seen that there are a few questions already. Yao Sompa says that if arbitration is based on consent, how can it be compelled by statute? Example, Act 913 Ghana. Does the insistence of arbitration as the means of redress by statute not oust the jurisdiction of the court's jurisdiction without and against the elections parties sought to have? Now, I have to say that there is a difference between statutory arbitration and arbitration as we are talking about. Statutory arbitration is not essentially the kind of arbitration that we are talking about. The arbitration is the chosen by the parties that this is how they want their dispute to be resolved. There are certain industries and certain areas where the statute says that you have to go for arbitration. Sometimes that has been interpreted to mean that once you submit to that industry and you know that this is the law regulating that industry, then impliedly you are also saying that you are agreeing to the dispute resolution mechanism that that particular industry has provided. I realize that our time is fast spent. Let me move to the next question. Please, can any professional be trained to be an arbitrator, or is it limited to the legal profession? No, anyone can be an arbitrator. It helps if you have legal knowledge, but certainly if you have a panel of 3 arbitrators, parties are looking at having a mix of different skill sets in the panel. They may want someone with legal knowledge, they may and then someone with some expert knowledge as well. So no, arbitrators are not only lawyers. We have accountants who are arbitrators. We have energy experts who sit as arbitrators. We have software experts who sit as arbitrators. So no, you do not need to be in the legal profession. But what then means is that the parties will definitely then be looking at having someone who has some knowledge of law and the arbitration procedures to augment your skills. I think that is the end of the questions we have. I don't know if anyone has anything else. Otherwise, I see that my time, I have 1 minute left. I really try to stay within the time because I don't want Abayomi to chase me off.
Oh, no. Right. I'm not sure if there's any other question, at least not in the Q&A box. Okay, so if you have any other question, we will still keep Naya. I know being a partner in the top firm, it's not always easy to get them. But I will keep Naya for another 10 minutes. If there's any question, you can just type your question in the Q&A box and Naya will try and answer them. Naya, thank you very much for that very informative session. It's always a privilege to listen to you speak and learn under your feet. Thank you again.
Thank you so much. Thank you for having me.
Now, we'll move swiftly into the next session. We have another is arbitrator in Ghana that will be taking us through the next session. Her name is Diana. Diana is a legal practitioner called to both the Ghana and the New York Bar. She's a senior associate of Sam Okuzeto and Associates, one of the leading law firms in Ghana. Diana is also a professor and lecturer in law at the Ghana Institute of Management and Public Administration, teaching ADR, company law, public international law, human rights. Diana is a World Bank certified trainer in corporate governance and also in human rights and ADR. And she has done, of course, a lot of trainings for lawyers and judges in Ghana and also in Sierra Leone and Liberia. Areas of research include ADR, corporate law, corporate governance, human rights, and business and international relations. Well, it's a special privilege to have Diana. Diana, of course, we got a great news recently. Diana is the Deputy Minister of Justice and Attorney General Designate for Ghana. Diana, it's a special privilege to have you to speak to us today. Hopefully, we'll still be able to drag you subsequently for more sessions. But of course, you may now have the floor. Thank you, Diana.
I thank you very much, Abayomi, for that very generous introduction. The way you and Nania excited, I am fortified in my opinion that you conspired to get me into this very humbling of it. So I would revenge in my own ways very soon. Let me say good morning to all the participants. It's always such a pleasure to share same platform with Nania, with Abayomi and Kenneth. And I would like to thank all participants for indulging us up to this time. I believe that Nania and Kenneth and of course Abayomi, they've done most of the work for me. My task here this morning is to speak to you about arbitral institutions in Ghana. I just joined in at the latter part and I saw Nania speak to you about, basic things on arbitration. And so give me just a few seconds while I share my screen with you. So Abayomi has summoned me here to speak to you about the essence of ADR and arbitral institutions. I believe I do not have to belabor the point much, but basically my session today will cover the following. One, the benefits of ADR. Two, what is arbitration? And I believe Nania has done a very good job on that. I'm going to speak to you about essence of arbitral institutions. And based on that, I'm going to talk about what we call ad hoc arbitration and institutional arbitration, just for you to appreciate more the essence of arbitral institutions administering arbitrations on your behalf between you and any other party where there is an arbitration agreement between you. I'm also going to introduce you to some arbitral institutions in Ghana. We're going to look at the advantages of institutional arbitration. And finally, I'll end my session with introducing you to the basic modalities in using arbitral institutions. Basically, the last leg is to answer the question, so what do I do if I have drafted an arbitration agreement or clause and there's an arbitration and I want to use an arbitral institution? How do I go about it? So the last leg seeks to answer these questions. I believe that my brothers and sister Nania have spoken to you at length about the benefits of ADR. And so by way of emphasis, I just want to explain why ADR is beneficial. You know, the story is always, or the illustration is always told about how even if you go to a hospital right now and you have various ailments, you have people with areas of specialty expertise in that particular area. For instance, if it is an ear infection, you would want to see the ENT specialist and not necessarily go to a general practitioner. If it is about your child, you'd want to see a pediatrician, for instance, and so on and so forth. If it is about cancer, you may want to see the urologist, etc. And so the same illustration is brought to bear in disputes or dispute resolution. The idea that a one cup fits all has clearly been criticized, and thereby litigation, which has for some time now been the only, if not the mostly used means of dispute resolution, has clearly been criticized because it is not all type of disputes that are best resolved through litigation, just like it is not all types of ailments that are best resolved by a general practitioner. Sometimes you need to have the expertise of certain groups of persons. Of course, I'm not oblivious to the fact that it is often said that the law is in the bosom of the child, but clearly, even within the court, you have sometimes important witnesses, expert witness to speak to the matter. While in ADR, for instance, in arbitration, you may have a sole arbitrator or a panel of arbitrators who are well versed. And so it makes easy because there's no added obligation of the panel now going to learn about the subject area. So depending on the SME you are involved, you may have certain persons within that particular trade who understand and who appreciate the nitty-gritties of that particular trade and who will be best suited to resolve, as neutrals, to resolve those disputes. So the same has been explained about the benefits of ADR, that it gives parties, and for you SME persons, the opportunity to appoint persons who are well versed in the particular trade that you're involved in, or who have some substantial knowledge to help resolve disputes. And of course, one of the other benefits I've talked about is party involvement, or what we usually call party autonomy in ADR. You know, as you file, most of you who have been, who have had to go through litigation before in the court, you will find out that when you file a matter at the registry of the courts, You do not determine, except that you determine the area. So if it's land, you file a land matter at the land court, but that's about it. You do not determine, for instance, let me bring it to Ghana that, oh, it is a Justice Anochijima in Land Court 2 that I want to resolve this matter. It is the registry that determines the particular judge for you. But with ADR, there is a party involvement, there's a party autonomy for a large number of things. Who becomes your neutral, whether it is mediation or arbitration, how you want the process to be held, etc. The procedures are all determined by the party. So the benefits summed up as very suitable mechanisms, because I've explained that you get a suitable or appropriate resolution of your dispute using the appropriate mechanism. So the ENT specialist scenario. This SME, I think, should go to this particular person because he's well-versed in the trade. Again, parties are more involved in the process, and they determine who and when and how the whole process should be resolved. Of course, we've talked about cost, and we realized that, and like Nania finished off saying that, I've had people tell me that, but arbitration is quite expensive. And I said, well, it depends on how you see cost or what you classify as cost, because of course, if you have, about $1 million case and you're spending about $200,000 to resolve it within maximum of a year, 6 months, as the case may be, somebody may see that as less expensive than having a case or a matter dragged through the courts for about 10 years. And perhaps every day that your lawyer goes to court, you're probably paying him T&T beside the filing fees and the legal fees that you pay to the court. And of course, I don't know how you quantify, for instance, the emotional stresses that comes with going to court for that number of years, let's say 10, 5, 2, 3, however you look at it. I don't also know how you quantify the time that you spend leaving your workplace or looking for witnesses, looking for other materials to help you litigate your matter in court. So when people say arbitration is expensive, I say, well, it depends on how you want to look at cost, or what is cost to you. For somebody who, there's a joke normally told of this woman who had BP or high blood pressure for a number of years, and went to see the doctor, so she was on medicine. And finally, it was a litigation she was involved in, and the matter was finally decided, and she won. It was decided in her favor. And some days subsequent to that, her personal doctor found that her blood pressure had stabilized and was quite good. And eventually they discovered that at every time when she had to go to court, every month when the case is adjourned and she has to attend court, you realize that automatically her blood pressure will just rise. I don't know how you quantify that as cost. I don't know how you quantify that. So relatively, I think the empirical research abounds that ADR is still relatively cheaper than litigation. Of course, added to it is the issue of time and speed for ADR. And of course, because of some of the tenets of ADR, such as privacy, where only parties and at best their lawyers attend the ADR process, and also one of the tenets of ADR being confidentiality, that any admissions, any processes, documents that are used but for the purpose of ADR would not have been available out there. These issues all remain confidential, especially for you SMEs. Some of you may have certain trade secrets. Some of you may have some ingredients by which you prepare your whatever food, restaurant, whatever products that you have. And of course, once you're taken to court, you'll be required to be examined to speak to some of these trade secrets that ordinarily you wouldn't want the general public to be aware of out there. And so that is also one of the added benefits of ADR. And of course, there are lots, but I also end with the fact that ADR helps to maintain business relationships. And for you SMEs, you need that more than ever, because it's a long-term hoping to rise beyond the SME level into bourgeois and very big enterprises. And so one of the things you want to have, whether it be your traders, whether it be your suppliers, whether it be your clients, whether it even be the community, even your landlord, however you look at it, you would not want to, as a burden enterprise, to sever those kind of relationships. And of course, ADR looks at a very mutually beneficial way of resolving disputes, and as much as possible to maintain the relationship. And that for me, is a highlight of the benefits of ADR in respect of the peculiar circumstance of SMEs. Now, having said, I believe that Nania has spoken about what arbitration is, because my focus, of course, you would have learned that there are various forms of ADR. The three main processes of ADR being negotiation, mediation, and arbitration. Of course, due to the malleability of ADR, there can be what we call hybrids of ADR. We can even have other modes of ADR, because the whole idea of ADR is that parties determine how their dispute will be resolved. Parties are part of it, of the whole dispute resolution. So there are other forms of ADR. You can talk about MEDR, some even look at early neutral evaluation, etc. But my focus today is on arbitration, because I am speaking on arbitral institutions in Ghana. But of course, in some few minutes, you realize that you would have learned that now that arbitration should be with the consent of both parties. I think I heard somebody ask a question that if it is by the consent of parties, why are persons compelled, particularly like under the Act 930 and other statutes, to go to arbitration? And I heard Nania respond to that. But fundamentally is that when we say arbitration should be by the consent of both parties, we normally make a distinction between that and mediation, where with mediation, parties can indeed be compelled to go for mediation, whether there is a mediation agreement or not, if you look at our ADR Act. But with arbitration, there has to be the consent. And when there is a consent, parties are bound by the consent, the agreement, to go for arbitration. And so where you draft a dispute resolution clause in your contract, and there's an arbitration that says that parties shall submit any dispute to arbitration, perhaps under a named arbitral institution. What it means then is that parties are bound, where there is a dispute, to submit that dispute to arbitration. Now, somebody may ask, so what happens if the other person does not attend arbitration? Like we see even in the courts, that you see somebody and they will never appear before the court. By the laws of arbitration, one party can decide it is in their best interest to attend arbitration, because with or without that arbitration, as long as due processes and notices have been complied with, arbitration will still go on. Your not attending arbitration does not stop the arbitration, where there's an arbitration clause or agreement, does not stop the arbitration from proceeding. Now, arbitration, just like litigation, there's a judicial hearing. I mean, I remember one of my students telling me after I've explained what arbitration is all about, I said, but then arbitration is just like litigation, except that you choose your judge and you choose where you want to have it and what route you want to have. And I said, yes. In fact, with arbitration, there's also a judicial hearing. When we say judicial hearing, it's the arbitrator or the arbitral tribunal, the panel of arbitrators or the sole arbitrator, whichever the case may be, actually listens to both parties, where evidences are adduced, there is cross-examination, just like we see in the court system, except, like my student rightly noted, the judge now in the case of arbitration is the arbitrator you yourself as parties jointly have agreed on. And you can also decide the rules and procedures for resolving that dispute. Again, a characteristic of arbitration is that there is a delivery of an award. So just as a judge in a courtroom gives a judgment or delivers a judgment, the arbitral tribunal in the case of arbitration delivers what we call an award. And of course, for us in Ghana here, our ADR Act, that is Act 798, if you look at sections 52, we're told that an arbitral award is enforced in the same manner as the judgment of the court. And so if there's an arbitration clause in your agreement, you are assured that if a person attends it or not, arbitration will go on after they've been served with all the processes and materials, and they still fail to attend arbitration. Arbitration will proceed, there will be an award, and the award that will be given, if it is in your favor, it is as if it is any court, a high court in Ghana, which has delivered that award, and you can enforce it against the other party, just like you enforce or execute judgments of the court. Of course, you will know now that in Ghana, arbitration and ADR is regulated by the Alternative Dispute Resolution Act of Ghana. And I would highly recommend, of course, now it's available even on the internet. You can just Google it. I would advise you as SMEs to get a copy of this ADR Act. Now, once there is an arbitration clause or agreement in any contract you sign with anyone, what it means is that once there's a dispute, you must necessarily go to arbitration. Now, how do you start? Normally, some people would state in their clause that they would use particular rules or they will go for arbitration under a particular institution or what we call an arbitral institution. There are two types of arbitration procedures. You can either have the arbitration under what we call ad hoc arbitration or what we call an institutional arbitration. Now, with the ad hoc arbitration, it is normally parties themselves who decide based on the rules. Now, one of the catch of that is that you may have to spell out a lot of things. So ad hoc is like you yourselves meet wherever you so decide, you know, and you decide to use, let's say, the rules of the Ghana ADR Hub or the Ghana Arbitration Center. It is up to you, but there's no fixed entity or institution that will help you to administer, to help you administratively. So every process of the ad hoc institution, it's a matter of decision and consent by the parties themselves. The reason why people usually recommend institutional arbitration rather than ad hoc arbitration is because of the benefits that comes with institutional arbitration. With institutional arbitration, you have an institution, an arbitral institution like the Ghana ADR Hub or the Ghana Arbitration Center, which will man or supervise. They don't dictate for you, but they normally serve as a backup. And so where there is a gap in some of the procedural rules, for instance, then the arbitral institution fills that gap. For instance, if you fail to decide the number of arbitrators, for instance, in your arbitration agreement or clause, and there is a dispute because one party A say, no, I want 3 arbitrators, party B it's say, no, I want just a sole arbitrator, 1 arbitrator, and it is difficult to decide. Now, the appointing authority being the arbitral institution, in that case, because you've adopted the arbitral institution to supervise the arbitration and you've adopted its rules to help you spearhead the arbitration process, you realize that the Ghana ADR Hub rule or the Ghana Arbitration Center rule will, for instance, say that where parties are unable to agree, for instance, on the number of arbitrators, then the arbitrator shall be 1. So then, because you're unable to agree, then there's a fallback on that arbitral institutions, which decides then what will be the number 1 in this case, if that is the rule. But of course, what with that ad hoc institution, unless you have used the particular rules like the UNCITRAL rules, which then tells you what will be the default or what will be the resolution where you don't agree on a particular procedure, then it becomes quite tough because when disputes arise, most of you know that it is almost impossible for the disputing parties to agree on anything at all. And so one of the advantages of institutional arbitration over ad hoc arbitration is that institutional arbitration will serve as a backup, will administer the procedure, the arbitration procedure for the parties, and where there is a lack of consensus on a particular procedural matter, it is the arbitral institutions, based on the adoption of its rules, will determine the matter in this instance. Now, arbitral institutions tend to play a very crucial role in arbitration regime. And I'm going to tell you why arbitral institutions, like where I am as the Vice President, the Ghana ADR Hub and the Ghana Arbitration Center, are relevant for SMEs while you plan your dispute resolution in future or presently. Now, they're very relevant arbitral institutions under 3 main themes. The first is that most arbitral institutions help in the pre-dispute process. Now, what I've classified as the pre-dispute process, and what does that mean? Well, the pre-dispute process, most arbitral institutions, once you get to learn about them and know about them, even provide for you templates of arbitration clauses. I remember that Nania says, yes, of course, I would advise you to always engage a lawyer as much as possible to help you in the drafting of the arbitration clauses. But most of these, almost all the institutions I know, arbitral institutions I know in the world, will usually have as an annex or a schedule, dispute resolution clause templates, which you can adopt and put in your contract. So if you go to the Ghana ADR Hub rules, for instance, if you look at our mediation rules and you look at our arbitration rules, we have examples of what a mediation agreement clause looks like. So for instance, you find at the back of our mediation rules that any dispute shall be resolved through mediation, etc. So you're able to, they help you plan the type of clause to insert in your contract. I'm also aware that most arbitral institutions like the Ghana ADR Hub also help to draft dispute designs, what we call dispute designs, like the Ghana ADR Hub. We, as a part of our consultants, we listen to the needs of the particular business, including, of course, SMEs, and we're able to help you think through or design a dispute resolution clause as part of your agreement. Of course, I remember I heard Nania also talk about adopt also other methods. So one of the things we tend to do more at the Ghana ADR Hub is that we create a whole framework of dispute resolution design, which, for instance, will say that when there's a dispute, you first attempt negotiation, mediation, etc., before arbitration. So the essence of arbitral institutions, that most arbitral institutions that you join or you join as a member or you follow through your engagement, help you to plan for your disputes in the future. And of course, one of the essence of arbitral institution, which is the substantial thing to talk about in respect of arbitral institutions, is that when the disputes in fact arise, they become very essential because they help to administer the rules for you. Because if it is ad hoc, where the parties themselves will have to go back and forth and decide every single procedural matter, it almost becomes sometimes there's a deadlock between the parties. Now, when disputes actually arise, and for instance, you would have already inserted in your contract that you will resolve the disputes through arbitration under the arbitration rules of the Ghana ADR Hub, for instance. So what it means is that when there's a dispute, you go to the Ghana Arbitration, Ghana ADR Hub or the Ghana Arbitration Center, whichever you choose, to help you administer to help you administer the arbitration. The last bit, I'm going to talk about the actual process of going to the arbitral institutions. So I'll stick to the essence of these arbitral institutions for now. So most arbitral institutions are very helpful in this matter, in helping to administer arbitration proceedings. Thirdly, arbitral institutions are also essential, and most of these arbitral institutions have also tend to be a source of training resource. You know, most arbitral institutions, beyond just helping you to plan your disputes in future or just helping you to go through the disputes properly and resolve it through arbitration, they also tend to give enormous training to their participants or to their members, as the case may be. So once you're a member, you usually get updates on the new trends and best practices of arbitration, for instance. Some have newsletters. Of course, some have, these kind of webinars and other trainings to help you appreciate and understand arbitral institutions and also new areas that may come up in arbitral institutions. One of the things I would want to add to this, the essence of arbitral institution, is also the networking opportunity that being a member of these arbitral institutions present to you. Of course, it is through these arbitral institutions, attending some of these trainings and webinars, etc., that I've been privileged to know people like Abayomi, Nania, of course, Nania in Ghana, Kenneth, and other people. Sometimes the training takers bring us together as practitioners of arbitration or advocates of arbitration, where we share ideas, we explore new areas of disputes and come up with a clear understanding. If it is to disagree, but to come on a clear understanding, substantial understanding of what is the best practices going on, all at the back of our mind that dispute resolution must always involve parties must always be customized to meet the special needs of the dispute and the special needs of the parties, in your case, the SMEs. So again, the essence of arbitral institutions is to help build this network, exchange ideas, and adopt and exchange best practices in making arbitration or ADR in general the appropriate method of dispute resolution. And so I don't know if you have heard it before. Some people have argued that the term ADR really is not alternative. Another name for ADR is just not alternative dispute resolution, but in some cases, appropriate dispute resolution, because you choose a dispute design which is appropriate to meet the needs of the particular business or the party. Some have also even opined that the abbreviation ADR in fact means what? African dispute resolution, arguing further that the whole idea of resolving disputes other than through the court is in fact originated from Africa, where we were resolving disputes using known, highly influential, reputable people of integrity and who were neutral and unbiased. That was what we knew before, whether it be in our community, some respected persons, or whether it be if it's a trade, we're using merchants who are well versed in the particular trade. And so arguably, some people have also opined that ADR is in fact African dispute resolution. So these are the essence of arbitration institutions, helping you to come up with resolution templates for the future, or sometimes even helping you to avoid the future, the disputes. But if there is a dispute, they help to administer the dispute for you to guard the process of dispute resolution. There's also practical knowledge for the future and appreciation of why ADR is an appropriate means of dispute resolution. And finally, you can't but recognize one of the essence of arbitral institutions being that as members of that arbitral institution, you strike a healthy network and help you to engage and also self-develop yourself and your business. So I think I've already mentioned through my earlier explanation the examples of arbitral institutions in Ghana. So really, what are arbitral institutions? As I've mentioned, these are institutions that are set up to help people like you who have arbitration clauses in your agreement, and where there is such a dispute and you want to go to arbitration, they welcome you. They help you set, so it's like they become like the registry of the court as we know it. So they help when you file something, you file it with the arbitral institutions. They exchange your whatever processes you've respectively filed. They serve it on the other party. They call you up. You have a hearing this day, etc. So I'll speak more about this at the last part. And so I've distinguished again between ad hoc and institutional arbitration. Well, there's the opposite of institutional arbitration is ad hoc. You don't have any institution really set down as the institution to administer the arbitration for you. Now, there are two examples of arbitral institutions in Ghana, and I encourage you to look more into these to follow them, join them as members. Of course, if they're beyond Ghana, there are a plethora of arbitral institutions, and various institutions offer this similar assistance and networking for arbitration. We have the LCIA, the CIAB, a lot of these people. Of course, I'll take the opportunity to also encourage you to be following Abayomi's African Arbitration Academy, and I have benefited a lot based on the programs that they have run and the newsletters that they have issued, etc. So in Ghana, and for the purposes of SMEs in Ghana, the two arbitral institutions in Ghana are the Ghana ADR Hub, the Ghana Arbitration Center. You can Google both of them. You visit their website and learn more about them. They have rules which you can adopt as the rules to be used for resolving your dispute. Now, one of the good things about the two hub, and of course, with the help of COVID, has taught us that even though both of them may be physically located in a particular area, their hearings move beyond their physical location. And so I've been privileged now. I'm currently wrapping up on one arbitration that I'm doing with the Ghana Arbitration Center. And I don't have to because of COVID, we do it online. Again, I remember when this whole issue of COVID came down, a lot of these arbitral institutions came up with webinars on the role of virtual hearings in of arbitration. So again, like I talked about, once you're a member of these institutions, you get to read into and join discussions on new areas of arbitration. So virtual hearings of in arbitration has become a very topical issues now in arbitration, and came up primarily when COVID disabled all of us from having any meaningful physical hearings and interaction. And so look more into these two, the Ghana ADR, the Ghana Arbitration Center, find their rules. Of course, you may have heard that if you're drafting an arbitration clause or agreement in your contract, and you are choosing a particular arbitral, the rules, arbitration rules of a particular arbitral institutions, it is a sin not to be conversant with the rules of that particular arbitral institutions. Because like I talked to you about, if for instance an arbitral institution says, well, if you cannot agree on who should be appointed arbitrator, for us, this is the mode of selection of arbitrator. So if you just blindly, let's say, adopt a particular arbitral institution to help you administer your arbitration proceeding without knowing the basics of of those arbitration rules, you may probably be choosing something you did not sign up for. And so my advice generally with arbitral institution is that you would want to know some basics of what the rules of that particular arbitration institutions indicate, so that whenever you adopt the rules to help you procedurally in running the arbitration, you would know exactly what you are signing up for. So the Ghana ADR and Ghana Arbitration Center now, both of them afford the opportunity to join as a member without necessarily being there physically. And of course, hearings too, due to COVID, has taught us that even arbitration hearings can also be done virtually. So the two examples are the Ghana ADR and the Ghana Arbitration Center. Now, what are some of the advantages of institutional arbitration? The advantages, based on what I may have told you so far, is that there is certainty and predictability of the dispute resolution process. Now, what do I mean by that? Because you will know the rules of that arbitration center institution, you would know that for the Ghana ADR Hub, for instance, hearing can be done virtually, online. You know that if the language, we don't even agree on language, there's English that is going to be used. This is the mode of selection of arbitrators. There's the listing basis, or this is how they allow parties to choose arbitration. Please excuse me just a minute.
All right, thank you everyone. While waiting for Diana, there's a survey at the end of the training.
Right.
Okay, Diana, are you back?
Yes.
Good.
Thank you.
Please
So
go
there's
ahead.
a sense of predictability of the procedure that will be adopted. Then I've mentioned that they cover certain gaps where there's a reversionary power to the institution. Generally, parties determine language, the rules to be used, the procedure to be adopted. But where parties omit, whether through inadvertence or intentionally, that power, that gap that may be created because parties did not agree on every single procedural matter, will revert to the arbitral institution, who will now fill in the gap where there is such gap. Of course, back to the certainty and predictability. For instance, you want to know how a particular arbitral institution, they deal with, for instance, expert witness, how they deal with how awards, the mode of rendering award, etc. So once you know that if I have a dispute, and if I go to the Ghana ADR Hub or I go to the Ghana Arbitration Center, this is how the process will run. And that gives you some sense of certainty or predictability of how the dispute resolution will be resolved. Of course, let me also mention briefly that most of these arbitral institutions will have a list of arbitrators. Now, they will have experts and not necessarily lawyers, as I heard one of the questions point out, not necessarily lawyers as arbitrators. So they will have, if you go to their website or if you inquire from these arbitral institutes, they have a list of arbitrators with their profile So for instance, if it's a survey dispute, if it's a building dispute, if it's a trade in cloth, for you SMEs, if it is a production, it is a manufacturing business, you would have, for instance, as part of the listed profiles of these arbitrators saying that, oh, Abayomi is one of the listed arbitrators of Ghana ADR hub. He has expertise in this area, he has expertise in finance, he has expertise in entrepreneurship, he has expertise in fund, etc. And so when you see the profile of those persons and it comes to selection of an arbitrator, of course, you are in a comfortable zone because you know that there is an expert as a listed arbitrator under that arbitral institution who would understand what business your business means, who understand them, for instance, that what time means for you in business, who understand or appreciate what business relationship mean for you in the business, and will then conduct the arbitration proceeding accordingly. So that would explain the point about arbitral institutions. Advantage of it is that it affords the relevant expertise in dispute resolution. And of course, the administrative support. Because when you have a dispute with somebody, you want to, for instance, file your reliefs, what you are claiming, so that the other party will know that, look, this is what you've done that I see as a breach of our contract. And that is why I want us to settle this matter. Sometimes even letting them how to serve or forward all those documents to the other party becomes problematic without the assistance of an arbitral institution. So the arbitral institution in this regard serves as the receiving institution. So whatever process you want to file, if it's a claim, if it's a demand, if it's an application for injunction, for instance, you file it at the arbitration arbitral institution, and they will intend, because they will require certain copies, most of them they require substantial, sufficient copies to enable them to keep one on their records, to give one to serve the other parties, and then also serve, give copies to the arbitral tribunal. So just like we see in the registrar that if you want to file a writ of summons, if you want to file your statement of defense, if you want to apply for injunction, if you want any relief, etc., the way you will file at the registry of the court. So the arbitral institution serves as that registry. When the disputes, the arbitration proceeding starts, you file all your processes with the administration or the secretariat of that arbitral institution. Then they will serve as the bailiffs and as we know them in court, and clerks, and they will serve the other party. If the other party also responds, they will also serve you same. If the arbitral tribunal, whether it's a panel of arbitrators or a sole arbitrator, wants to notify you to take particular action, or what we call procedural orders, he sends it to the arbitral institution. The arbitral institution will also serve both parties with the procedural order and say that, look, the arbitral tribunal said you should all file your witness statement within this particular date. You should bring your witnesses on this particular day, etc. So the arbitral institution gives that administrative support to both parties. I've also mentioned to you that one of the advantages of institutional arbitration is the template dispute resolution clauses that they provide, and of course the training in arbitration and other ADR methods that you will not have. You may have, but it's more run and administered by these arbitral institutions. I want you to note as the set point, one of the advantages of ADR is the invaluable networking opportunities that being a member of these arbitral institutions affords to its members. Right, so I will now, the last slide, the last session, I will seek to talk about the the basic modalities. And for this, I want to focus more on the Ghana ADR Hub, where I'm a vice president, but also hastily add that the rules are not different substantially from even the Ghana Arbitration Center or almost all the arbitral institutions that I know. So for instance, there are two ways by which the Ghana ADR Hub usually receives or starts arbitration proceedings. At the Ghana ADR Hub, we sit there And we wait for disputes to come. So don't start looking at me like we are like the coffin maker who is sitting there and hoping somebody dies. Not really, but we, in a very positive way, we're there waiting for parties who have in advance or at the point of dispute decided to resolve it through arbitration. We are there. Now we receive arbitration proceedings in two forms. So there are some times where we have an order by the court. So usually there will be an arbitration clause or an agreement in your contract. For instance, Party A and Party B, and they decided to supply, let's say, raw materials for, let's say, the production of some food products, shito or to clothing, etc. And there's a breach of that agreement. But as part of the contract to supply those raw materials, it's a dispute clause that says that where there is a dispute between us, we will resolve it through negotiation. If negotiation fails after 30 days, there's no result, we'll go through mediation. If mediation doesn't resolve it, then we'll go to arbitration. And of course, you would hear from Nania that arbitration is final and it's binding. So never put in your clause that if arbitration fails, then we'll go to the court, because arbitration will never fail. There will definitely be a hearing. There will definitely be a delivery award, whether a party attends or not. So after arbitration and the award is given, it is final. It's not as if arbitration fails, then we also go to the court. So then Party A, they might have attended this webinar and found out that it's best that you use an arbitral institution to conduct or administer the arbitration proceedings. So they probably had in their contract that if there's a dispute, we resolve it through the arbitration rules under the Ghana ADR hub. So Party A is not happy that Party B has violated a provision of the contract to supply at a particular date. So sometimes this is how we get the proceedings at the Ghana ADR. Either through inadvertence or willfully, Party A will sue Party B in court that we had a contract, there was an agreement to supply on a particular date and time, but he has failed to do so, and I have incurred some loss based on that. So Party A goes to court. So Party B then responds to court by our ADR Act of Ghana, Act 798. When there is such a dispute, the defendant, in this case, Party B, once he enters appearance to the writ of summons that had been initiated at the court, he would then ask the court to stay the proceeding and say, my lord, I don't think this matter should be decided in the court here because Party A and B, Party A and I, we entered into a dispute resolution clause that says that we're going to go to arbitration at the Ghana ADR hub. So by law, again, which is the Act 798, then the judge is mandated to do what we call stay proceedings. So the judge says, that's true. Let me see your arbitration agreement. Oh, your contract, right, is there. Clause 10 clearly is there. It says that you shall go to Ghana ADR. So I'm going to stay proceedings, right? I'm not going to go on. Both of you, I'm ordering you to go to the Ghana ADR hub for arbitration. So normally you realize that we have this order and then the claimants will come to the Ghana ADR hub and file what we call a request for arbitration and attach all the orders, including his the disputes, the claims, what he's asking for. Sometimes they'll say that, okay, I'm adopting my statement of claim, which I filed at the court, which I forgot and I filed at the court because it wasn't supposed to be in court in the first place. I'm adopting it as my claim in this arbitration. So we've had that instances before. But the best mode, which I would advise you, because now going to the court before there's a stay and coming back will all be eating into time and money. So once you know that there's an arbitration clause in your contract, you must go to arbitration. Then you don't go all round before. So the second mode by which you've been receiving requests is that, again, Party A and Party B have a dispute clause that says they go to arbitration using the arbitration rules of the Ghana ADR hub. So Party A is very knowledgeable in arbitration and says, oh, so this breach of contract, I've asked him to pay me damages and he's not paying. So this is a dispute. So I'm going to go to the ADR hub because that is what we have in our contract. So if that is the situation, which is mostly the situation, because once you know there's an arbitration clause in your contract, you don't waste your time going to court to even get a stay of proceedings before you come back. It's all time and money. So such a knowledgeable party will say, well, I remember we said Ghana ADR. So what do? If you look at our arbitration rules, which is online, which is on our website, it says that if you think there's a dispute and the dispute you agree to go on arbitration, and you've specifically chosen the Ghana ADR, for instance, this is what you do. I'm also going to later explain to you what you do if you haven't chosen the Ghana ADR, but you still want to come to the Ghana ADR. So let's start with the first one, where you've chosen the Ghana ADR hub. So you go strictly according to what your contract says. You come to us. Now, most of these institutions have administrators. Now, you don't even have to be physically there. You can contact them through email or phone. You do what we call a request for arbitration. So you can title it just like you have it Part A versus Part B. And then the heading will be request for arbitration. If you look at our rules, it says that you write to the administrator of the Ghana ADR rules and say that, look, I have this dispute, basically give us a brief facts of the dispute, and then spell out what you are claiming. That I have this, there's a contract dated 9th March 2020 between my company or my business or between myself individual as a person and the other party, which agreement was that he would supply me with these raw materials, let's say herrings, fish, whatever, to enable me to prepare my shuttle as a business I operate. Now he had failed to, even though I've paid these sums, he has to date failed to furnish or supply these raw materials, and because of that, we've incurred damages, and therefore I'm claiming this amount for breach of contract. I'm also claiming interest on the amount. I'm also claiming this damages, general damages from the other party. So you write to us as the Ghana ADR and request for arbitration. And then in the request for arbitration, you let us know who the other party. So you give us your address first of all as party A. You tell us that my address of claimant, the one who first goes to the ADR hub to claim something against the other party is called the claimant. So you give the address of the claimant and say, address for claimant is, let's say, Dapaah Okoshi, plot 1, house number 332, Dapaah Okoshi, Accra. Telephone number is this, so in case we want to reach out to you. And that's why you give us all the contact details that we need is essential for you, the claimant. You also give us the contact details of the other party whom you are bringing to arbitration, or what's in litigation, you say the one you are suing. You give us the contact details of that other party and give us a brief facts of the dispute, what it is about. And you give us what you want what you want the arbitration tribunal, the arbitral tribunal you'll be choosing, what you want from them, what you are requesting from them. Now you file all these documents with the Ghana ADR. Once we receive your documents, the request for arbitration, the contact details, the brief facts, the claim, the release, etc., we will then write to the other party that we have received this claim and serve all your documents that you have served us. We will serve it on the other party. Now, when the other party receives it, they are also required then to file their response to the claim. So they also file a response. So just like you sue somebody at the court, you issue a writ of summons. So in the case of the claimant, the writ of summons will be the request for arbitration. And in the case of the party B who is responding to the claim as a respondent will be like your statement of defense if you were in court. So the other party will now respond to the Ghana arbitration, also file what we call their response to the claim and say that I reject, I disagree, or just like you say, I deny clause 1, I deny clause 2. Yes, I deny clause 2 partially, but I also say that there's no, when we agree that they would be the one to receive payment, but the first day that we went to supply, there was nobody on the premises, and so we had to go back. And since then, the goods have rotten, and it is not our fault because they were also not at the place of delivery to take delivery. So you also respond, and if you also have a counterclaim as the respondent, you also include a counterclaim that says that Well, even we also want to counterclaim against them because we spend this amount of money to drive all the way to Latabi Okoshi from Bogatanga to deliver the goods. They were not there to take up delivery. We had to come back, transport the monies we spent, etc. We've also lost the goods because we could not resell it because they got rotten, etc. So if you also have a counterclaim, as the respondent, you also file your counterclaim and you deny or admit what the claimant has first said. And if you have a counterclaim, you also add, and you also let us know what you're also claiming from the other party, assuming you have a counterclaim. And then after this, then usually you have to pay the administrative fee because of course the arbitral institution receiving all your documents and passing it over to one another and serving over on it involves some cost. So usually, again, it's also crucial if you are choosing a particular arbitral institution to know what the administrative costs are. Most of these arbitral institutions charge administrative costs based on the amount involved in the arbitration. So you want to know, for instance, if it's some will charge between, let's say, 5% to 10% of the amount, but if it is beyond, let's say, 1 million, it is capped at a particular figure. Of course, in doing your economics and calculations on your dispute processes, you'd want to be conversant with some of these charges or administrative fees. Of course, I know some institutions also, the arbitrator, listed arbitrators also have their charges. Some charge hourly, some charge based on the expertise, etc. So again, it's something you want to look more into it in determining who you choose as an arbitrator, for instance. So after you've done all the services of what we call your pleadings, your claim and your response, and then there's a reply. So party A says, no, it's not true that when you came, I wasn't there. In fact, we were there, the agreement was 9 a.m., but you came 12 hours later. So if there's a reply to the response by the party B, you also file the response. And then usually you proceed with the help of the arbitral institutions to appoint, to constitute the arbitral tribunal. So if it is easier for parties to agree that, okay, we're going to go ahead with arbitration, and we know that we see that Mr. Abayomi is one of the listed arbitrators of Ghana ADR. So both of you agree that we want Abayomi as the arbitrator. It makes life very easy for all of you. But sometimes you may not. And usually, again, once you don't agree, the arbitral institutions fall in. For instance, you will find that with the Ghana ADR, which I'm speaking to, where there is at the point where you need to constitute the arbitral tribunal, the judges, the arbitrators, to sit on the matter, and you do not agree, we use what we call the listing system. It's part of our rules that if both of you cannot agree to decide on Abayomi, for instance, we will help you to agree, because definitely we have to constitute the tribunal one way or the other. So for the Ghana ADR, we use what we call the listing system. So the administrator of the Ghana ADR will write to both of you and say that, okay, so you need arbitrators, right? You haven't been able to decide. Both of you haven't been able, you have chosen Abayomi, party has chosen Abayomi, party B has chosen Kenneth. You seem not to agree. So this is what we're going to do. We're going to send you a list of our arbitrators, both of you, the same list. And you are to tell us in order of priority whom you like. So tell us, say, number 1, we'll choose Abayomi, number 2, we choose Kenneth, number 3, we choose Nania, number 4, we'll choose Diana, for instance. Party B, you also do the same thing. Now, when you receive your choice of the list given to you, the common denominator, the highest common denominator among what you have chosen. So if you realize that Party A would have chosen Abayomi as first, but Kenneth as second, and Nania as third. And Party B would have also chosen Nania as first, Kenneth as second, Diana as third. So you realize that the common highest denominator among the two will be what? Kenneth. So by the rules of arbitration, once we use the common denominator, highest common denominator among, then Kenneth, by the rules that you have chosen, that you use the arbitration rules of the Ghana ADR, what it means is that Kenneth will then be chosen for you by the arbitral institution as the arbitrator. And thereafter, the arbitral tribunal is deemed to be constituted. So when we say arbitral tribunal, it's either the sole arbitrator or the panel of arbitrators, usually 3, 5, or the odd number that parties may decide. So then usually after the request for arbitration, the response, the payment of the relevant administrative fees, the constitution of the arbitral tribunal. So if it is a sole arbitrator like Kenneth, then Kenneth meets the parties, usually through what we call pre-hearings. And then he sits down with you and says, okay, I've received your claim. I've also looked at your response. Now let's agree. I want both of you to file in arbitration. We use what we call witness statements. I think most of you are in court in Ghana now, are aware that now in our trials, we use witness statement. So you file your witness statement, which is the evidence. So witness statement, for those of you who are not conversant with witness statement, unlike previously where if you want to litigate a matter, you stand in the box, what we call the witness box, and then you give your oral evidence so that the judge now notes everything down. We have now reduced all of that into writing. So whatever you would have said, whatever evidence you would have given while standing in the witness box, now you all put all of it in writing as witness statements, and you attach all the evidences. Let's say if it is the contract, you attach it as exhibit. If it is an email he sent you admitting that, oh, I'm sorry, we came 12 hours late, we are sorry, we'll pay up. You add all your evidences as exhibit to the witness statement. So it's at these hearings that the arbitrator, Kenneth, in this regard, will say, okay, so file your witness statement at this time. I want to know the number of witnesses you're bringing, and we're going to have our hearings on this particular day, Monday, Tuesday, Wednesday, at 3 p.m., at 6 a.m., at 8 p.m. Of course, the arbitral tribunal usually does that with the consent and assistance of the parties, where they would throw it to the parties to decide, for instance, the day of hearing, the time of hearing, etc. If they're unable to agree, usually the rules of the arbitral institution will determine and will give the discretion to the arbitral tribunal to determine based on tenets such as equity, tenets such as speed, tenets such as reasonableness. So to decide on issues that have not been decided, which is reasonable and equitable in the circumstances, and enables the matter to expeditiously be dealt with, etc. So then when all these have been decided, the arbitrator says, file your witness statement. When you filed everything, usually there's the final pre-hearing review where you determine, you take all the checklists. Have you filed your witness statement? Yes, check. Have you also attached, are you bringing any expert witness? Yes, we are bringing a surveyor, or we are bringing a biochemist to come and explain that it is the 12 hours delay that caused the hearings to rot, etc. So yeah, you will bring expert witness. Okay, check. Yes, how many days would you need for the hearing? 2 hours for 2 days, 2 days. Okay, good. You, how many days? Okay, good. Okay, then we are going to agree next week, Monday and Tuesday. We'll give 4 hours to each of you to cross-examine the other party. Because you would have filed witness statements, you don't now bring your parties to give evidence. You only bring them so that they can be cross-examined on the witness statements that they have filed as their evidence to be used in the arbitration. So that's why we say arbitration involves a judicial hearing. So the arbitral tribunal will now listen to the cross-examination, will now read through and review the witness statement that have been filed as the evidences of the respective parties. So then there's the day of the hearing itself. Of course, you could decide a whole lot of things. For instance, we're going to use the English language, we're going to use tree, we're going to need interpreter, etc. All of those are decided before the date of hearing itself. But again, let me add that in as much as the arbitrator is going to determine the matter, he does not do so outside the scope of the contract or the arbitration agreement or clause, or neither does he do that outside the scope of law. So for instance, if parties have decided, for instance, that they're going to use the rules of, let's say, the constitutional rules or the rules of procedure of, let's say, a named or the substantive law, the law that's governing the arbitration proceeding should be, let's say, French law. The arbitrator cannot on his own says, no, I'm going to use English law because that's what I think would help. So unless where parties have expressly determined, for instance, the governing law, etc., the arbitral tribunal must stick with that. It is where there is no clear determination of, for instance, the governing law, that the arbitrator may then decide to use what does the arbitral rule say of the Ghana ADR, that where there is no clear mention of what the governing law It's which law am I going to use? In our case, is what? The laws of Ghana. So then I'm going to use the laws of Ghana. So the arbitrator then hears all these matters, listen to it like a judge would do in a judicial manner, cross-examination, notes all the laws that are applicable, and then delivers what we call an award. Now, it is that award which is seen as a judgment of the court. So Kenneth Ohinimenu listens to both parties, reviews the evidences they have presented through their witness statements, through their the cross-examination, the evidence that came out, and then he's given a time, sometime usually not long. And of course, the whole idea behind ADR is speed. So the arbitral tribunal safeguards the procedure. So usually where there is a delay by one of the parties, usually cost may be awarded, or sometimes they will be given some warnings that if at the next agenda you're not able to produce this, the arbitral proceedings is going to go on, for instance. So the whole proceedings is conducted with expeditious trial in mind, that it will be done expeditiously, of course, without slaughtering the rule of law and the laws that have been decided by the parties, without slaughtering those two. So after everything, the hearing, usually the parties will, just like courts, will deliver their closing addresses to the parties where they sum up everything that they have brought to the table, to the arbitration chamber, that this is our case, this is our evidence. We've also reviewed the evidence of the other. They have still failed to disprove our claim, etc. And so we believe that we should be, the award should be given in our favor. Then finally, the arbitrator, the arbitral tribunal will deliver the award, which most arbitral tribunals require that the award be reasoned, as in the award shouldn't say I find in favor of party or party, but should explain why the arbitrator finds in favor of party or B. Let me go some few steps back. So in the course of the hearing, you can also, if you want to bring a witness to testify on your behalf, the witness that you want to bring, for instance, your caretaker or your general manager who was there at the morning to receive delivery, but waited for 12 hours and then nothing happened, together with, let's say, one of your office clerks were there, then they want to testify to add up to your case. They also would file in what we call a witness statement. In addition to you as a, let's say, the sole proprietor or the manager, they will also file witness statement. If there is any expert witness, like I mentioned, that you want to bring to the arbitration to testify on your behalf, so that your claim will be upheld over the claim, the counterclaim of the other party, you also bring such an expert witness who will also file a witness statement. So mostly for arbitration, to the point that you would have oral hearings where there's cross-examination. Most of these things are written for and served on the other party, so that they can have an answer if they so wish for whatever you file. So after the award, two things can happen. I haven't forgotten, I'll come back to when none of you have chosen any of the arbitral institution, what happens. And usually that's very risky, but I'll tell you what happens. So usually when there's an award, two things can happen. Either that the parties appreciate, understand, and are amenable to complying with the award. So let's say the arbitral tribunal finds for party A and says that party B has breached the contract, and therefore we award, let's say, 100,000 cedis damages in favor of party A. Two things can happen. Party B can say, okay, it's okay, no worries. We admit fault, so we're going to pay the 100,000, and they pay the 100,000 to party A. But usually, sometimes to party B will say, well, I do not agree, or whether through whatever strategy they may not pay after, of course, consistent urging upon them to pay the 100,000. Now, what do? You now have an award in your hands, stamped, neatly signed by Kenneth with his beautiful signature, stamped by him and the Ghanian ADR. What do? That's the next question people like to ask. What you do is that you enforce it in court. Now, our act says that the arbitral award can be enforced in the same manner as a judgment of the court. So for those of you that are not conversant with litigation, whenever you go, you take a matter to court and there's litigation and there's, people are fighting and you finally win, the day they give judgment and you finally win. and they carry you and put that powder on you. That's not the end of the matter. The real matter comes because you have to now go enforce the judgment against the other party. So for us, what the law, the Act 798 has done for us under arbitration is that once you get the award, it's like the day they have thrown that powder on you at the court. But then you can, when you win a judgment in court, you still have to do what we call file entry of judgment. Then the court will either you go and garnish the account of the party who is not willing to pay, or there's a fee or whatever. So once you go to that, you get the award, you go to the court. The law says that you file and it's an application you file with the court, application for enforcement of arbitral award, pursuant to section 52, 57 of Act 798. And you go and tell my lord, on this day we had this arbitration, and this is the award I've received, but the party B is failing to pay the 100,000. The court will say, oh, I see, by Act 798, because the award you gave, even though it was given by Kenneth Ohini, who is a law lecturer and not a judge, I am to see that award that Kenneth has given as a judgment. So I hereby adopt that award that Kenneth has given, and I'm going to help you to enforce it. So the court machinery or all the enforcement procedures that we have in the court can be triggered. You can go and garnish the account. So the court will order the bank, let's say ADB is the account, it's where Party B keeps its account, or the business account. The order Party B, ADB, to come to court and come and tell us how much Party B has in their accounts in their name, and then order that amount be used to pay you. If they don't have account in the money, you can go for any property that belongs to them. Use all the known procedures of enforcement. And so you would have bypassed all the 10 years of litigation up to the point of delivery of judgment, because now you have an award in your hand, an arbitral award in your hand. And so by law and by Act 798, the court is mandated, after you have gone through this process called arbitration, and the other party fails to honor the terms of the award, to comply with the terms of the award, the court mandates the High Court, and it is the High Court that you go to adopt, upon application, to adopt the award and enforce it in your favor against the other party B, using all the known processes of execution, which I've talked about, either going to the account or anybody who holds money on their behalf to take that money from that person and pay you, or auction any of their properties to pay you, etc. So that is why arbitration is really now one of the advised and recommended method of disputes. While it is fast, while it uses expertise and people who are well versed in your area to resolve the dispute, the cherry on the top is that it is like a judgment of the court. When you finally come to award, and Nania told you can't even appeal, you can only set it aside under very limited circumstances. For instance, you found out that the arbitral tribunal was bribed, there was fraud, corruption somewhere. The arbitral tribunal did not use the known laws or procedures that you agreed to. That's why I said that even though the arbitral tribunal decides the matter, he does not decide the matter outside the scope of what parties have decided. So if we decided that French law will apply, will be the governing law, and he went to use English law, he has clearly acted outside the scope of what we decided. And so it is a basis for coming to court to say, no, I don't agree with the award, and you should set aside the award. So that's one of the beauty of arbitration. Now, let me finish off by saying that what happens if you would have a pathological arbitration clause, and you just say, oh, any dispute will be resolved through arbitration, full stop. Clearly, the intention of Party A and Party B is to resolve their dispute through arbitration, but the question is where and how. And normally you don't state whether Ghana ADR or Ghana Arbitration Center. So what happens? And again, I would say I will not recommend such a dispute arbitration clause in your contract, because it lends itself to a lot of issues. And if you are not careful, and Party A and B are not wise in their own ways to agree on the procedural matters, you have back and forth, and it will, you will frustrate, or you end up going to court for the court to order you to choose in order of preference which arbitral institutions or which rules you want to use. So again, we also have institutions where parties did not expressly provide that they will go for arbitration under the arbitration rules of the Ghana ADR. We've had such a situation. One, how do you resolve that? The best is for both of you to agree that you are in a quagmire of a sort. So the earlier you agree, that you will now go to the Ghana ADR Hub or the Ghana Arbitration Center, the better. So sometimes, again, they will end up in courts because they are not agreeing that they'll go here or there. Now, the Ghana ADRs Act provides for an ADR center, which ordinarily would have catered for some of these issues where there's not agreement. But as it stands now, the ADR center has not yet been established and is not also enforced. So normally what the courts will say is that, well, for all intentions, you want to go to arbitration, but you seem not to agree. So you're going to list in three, perhaps in, again, the listing method, your preference for which arbitration institution, or if you're going to use an ad hoc arbitration where you yourself will do the arbitration and nominate your own arbitrator with the help of the court in order of preference, which rules you're going to use. But we've had in situations where upon consultation with the parties, the courts have sought and have procured the consent of both parties that they will go to arbitration at Ghana Arbitration, and then they are ordered to come to us at the Ghana ADR Hub. Now, the point is, and I would perhaps add that for SMEs, it is imperative that you understand that once you have agreed to arbitration, and even though it is a pathological clause, unless both of you agree again to discard arbitration, you are to go to arbitration. Because once you've agreed to it, the court will enforce that, ensure that you go on. So one party cannot say, well, now I'm no more interested in arbitration. And the other says, but I want to go to arbitration. The one who is saying, I'm not interested, does not have a choice. Once he has chosen arbitration, it is arbitration it shall be. So when there are some of these pathological clauses, for instance, you don't know because you didn't choose which arbitral institutions or which rules you're going to use, it is imperative and good for both of you at that point to come to some form of consensus that, well, we are going to then go to Ghana ADR Hub or the Ghana Arbitration Center. So in other words, I will end by saying that I'm here to highly, highly recommend arbitral institutions for you, not because you just have disputes now. You don't have to wait for you to have disputes now. You can follow, you can join these arbitral institutions as a member. And as I've outlined the essence of these arbitral institutions, even before you get to the point where you have a dispute, you are bound to enjoy the fruits of membership of that arbitral institutions. I'll end here. I think we have just about 15 minutes, and I'll use that opportunity to answer any questions that may nag your mind. On that note, let me first of all appreciate Abayomi and his African Arbitration Academy, and of course, all the sponsors that have helped the Academy to make this webinar a success. And let me also thank you, participants, substantially, because my whole career has been talking, but if there are no participants or students to listen, then my talking shall be in vain. And so let me thank all of you for indulging me all these almost 1.5 hours. I'll stand by for questions. Thank you very much.
Thank you, Professor, our Honorable Deputy Attorney General, Designate, for that excellent presentation. Of course, as usual, I think we have a couple of questions in the Q&A box. I don't know if you want to quickly answer them.
Right. So
I can read them out.
Please do.
Or you can take them. Okay. So the first one is by Robert. It says, who pays for the arbitration services and how about the expert witness? Essentially about fees.
Essentially about fees. So thank you, Robert. So both parties pay for the arbitration services and the expert witness. So for instance, I've mentioned that you would want to know the administrative fees for most arbitration. So let's say if it is 7,000, the Ghana ADR app says we charge 7,000 for every arbitration. What it means is that if there are two parties involved, Party A and Party B, they pay equally. So Party A will pay 3,500, Party B will pay 3,500 cedis. Again, that is beside the fee that the arbitrator will charge. The arbitrator will usually at the pre-hearing, before the trial, the hearing itself starts, will say that, well, based on the enormity of the case or based on the number of hours that will go into this case, I'm going to charge both of you $20,000, for instance. What it means is that the parties will share that $10,000 equally. If there are three of them, they share it equally. If they are the same with the administrative fee. But normally this is what happens. Normally the arbitrator says, I'm going to charge 10,000 Ghana cedis. So what it means is that both parties should pay $5,000 each. But then usually, and I normally do that in my arbitration, I say that, look, if you should pay, let's say before the hearing starts, if one party is not paying his bid, which is the half of it, the other party, so party A can pay all, the full amount, which is $10,000. And then in the course of the award, I would take note of the fact that they failed to pay. So if I was going to even give the award in favor of B, the one that didn't pay, and I was going to give that party, let's say 20,000, I will make note in the ruling, in the award, that I take note of the fact that the arbitral fee was solely paid by party, which is 10,000. So instead of the 20,000 that I would have awarded to party B, I'm deducting $5,000 of it. So now party A only owes party B $15,000. So the answer to it, the fees is that it is paid equally by the parties involved, depending on what is charged by the arbitral institution and the arbitrator. I think I've seen one that says, what is the minimum fee payable to the arbitrator? It's very difficult to tell. Again, I've told you there are various modes of payments for arbitrators. In fact, I learned in the US, where I did most of my arbitration training, that, I mean, some arbitrators charge per hour, because they look at, for instance, and your experienced arbitrators will probably be charging, let's say $200, $300 an hour, while the amateur ones probably be charging $100, because a lot goes into it. Again, some arbitral institutions also give you some guidance. The arbitration test fee will probably be 10% of the amount involved. But for us, even if it is not stated, whether it's by the arbitral institution or ad hoc institution, Act 798, which is on ADR in Ghana, if you look at fees is regulated under Section 22 of the Act. It says that it gives you parameters for determining what the fees should be. And I know that all these arbitral institutions are aware of the effects of Section 22. So you cannot charge in vacuum. You cannot charge, as it were, without consideration of these parameters. And one of the parameters under Section 22 include that the time involved, the enormity of the case, etc. Again, you asked about witness, the expert witness. If you bring that expert witness, you pay that expert witness. So I won't be able to tell you what is the minimum fee payable to arbitrator, because it depends on arbitrator to arbitrator. Yes.
Absolutely. Maybe I can come in.
Sure.
I think the issue of fees is one that is very important, particularly for SMEs. I've been appointed, to sit as arbitrator in about 3 different arbitrations that did not proceed because of fees. One I actually wanted badly, given the nature of the dispute and the amount involved in the claim, right? But the parties are not just ready to pay that huge amount. And you know that if it is not institutional arbitration, what we do typically is to charge ad valorem, looking based on the value of the claim. And so the parties are not ready to pay. I wanted to maintain a professional stance, of okay, well, but even arbitrators fees can be negotiated, right? You can negotiate with the arbitrators, and they can decide to come down on fees. But for SMEs, which is why institutions like the Ghana ADR Hub and the Ghana Arbitration Center, they have sometimes dedicated packages for SMEs or small scale arbitration, where the fees of arbitrators are capped. So you know that if you are a 5 million naira claim, the fees are capped. So it makes it affordable for SMEs to be able to settle and resolve their disputes amicably. Thank you, Prof.
Yeah, thanks. That's great. Yes, next question.
So next question is that if you want to become a member of the Ghana ADR Hub, is there any membership fees? As the Vice President, I'm sure you should be able to answer this.
Yeah, definitely. So again, if you go to our website, there's the GhanaADR.org, or you can Google Ghana ADR, that we have a list of the types of membership that we have. We start from the student membership, which is free for all tertiary students, students of tertiary institutions that are interested in all forms of ADR. So their membership is free. And we have membership, I think it ranges from 250 cedis for associate member. We have member, and then up all the way to fellow. And of course, for us, your membership is also distinguished by the path, whether mediation or arbitration. So if it's your associate member, into bracket mediation. So we have all the listed fee, but it starts from student membership, which is free, and then it goes to associate membership, which is 250, 500, 750, up onto the fellow, which is 1,000. And of course, to be a member, you'd usually be required to take some number of hours of training. So for instance, the basic one, which I know from us, which I can readily tell you now with the associate member, is that at least we run courses, 40-hour courses for both lanes, mediation and arbitration. So you would be required to take these courses online or in person, depending on how the COVID situation runs, and then you are now certified. Also, the Ghana ADR usually receives, if you have certificates from other institutions, like if you're a CIAB member or you join Young Geka, LCI, and you show us, you finish us with certificates, and we verify and know that you've run those courses with that particular arbitration. So sometimes we jump you from particular rank of membership. So you probably start off with, let's say, a member straight away, instead of starting with associate member all the way to fellowship, etc. So yes, and I would encourage you to look more. So there are fees, quite nominal fees. The advantages of payment of these fees is that we share with you our newsletters and upcoming training. Some of our trainings, because you're a member, you get huge discounts to join those trainings, etc. And of course, it's easier to be listed as an arbitrator, for instance, at the Ghana ADR when you have been a member, because we're able to verify and confirm that you've had the requisite training and can now migrate from just being a mere member to, in the future, hopefully becoming a listed arbitrator under the Ghana ADR. One of the things about Ghana ADR, we also keep what we call international arbitration member status. Okay, so we have certain persons who are listed as international arbitrators under the Ghana ADR. So it's a progression really, all with a view to maintaining some standard required of who a member of arbitration or mediation, or who an arbitrator should be. Thank you.
Thank you. I think you've answered one of the remaining questions on how long does it take to undergo training to become an arbitrator. The last one, because I don't intend to keep you any longer, I know you're a very busy person, is using the listing system. Does that entails imposing the arbitrator on the parties, and when the parties are unwilling?
Right. So again, there doesn't, let me say yes and no, and this I'm going to explain that, you see. So the listing process, like I explained to you, usually will give you the list of all arbitrators. And the last time I think we had our meeting, if I should count even the international arbitrators, we're looking at about 12, minimum of 12 arbitrators so far, the Ghana ADR. So if you're unable to choose, we give you the list of the 12. So party A takes 12, party B takes 12. So administrator of the HAB tells you, okay, so within 14 days, get back to me. List out of the 12, which you prefer. So your most preferred should be number 1, up onto what, number 12. And usually you find that there will be a common denominator. Either your preferred one will be your second preferred one will be the first preferred of the other, or even the same second preferred or the third preferred. So you realize that we see some commonality between the two of you. So in a way, I don't know if you see that as imposition, but where again we don't even find, and usually it is hard that you won't find a common denominator, but where you don't, then the administrator of the Ghana ADR will determine based on what I said to be the highly voted for. So if we don't get a common denominator, like let's say all of you chose Abayomi as number 1, then we'll look at which one is the highly voted for. So in a way, someone may see it as imposition, but I do not tend to see it as imposition, because it's also part of your preference.
Thank you again for that excellent presentation, Diana, and we wish you the very best in your new role.
Right. Thank you very much for having me. And I believe that this seminar will provide opportunity to enable more people who want to ask follow-up questions, of course, from the academy and your friends here in Ghana. Thank you.
Thank you. And special thanks to all the participants for taking our time to attend the training today. I hope you found the sessions useful and rewarding. And we're grateful to GIZ Ghana, the Africa Arbitration Academy, for for the great supports, that they've provided to us in putting together this training. Just to note that certificate of attendance, will be issued by the Africa Arbitration Academy to all attendees. So please send to us your full names, the way you want those names to appear on the certificate, and we will send to you your certificates in due course. And also complete the survey at the end of the session because we'd like to have your feedback. There's another training in June, at the end of June, on online dispute resolution that has been specially packaged for you, and that will keep you apprised, of the training dates and the activities in due course. So enjoy the rest of your day. If you have any questions, please send to us at info@pensburylaw.com, and we'll surely respond to all your questions. So enjoy the rest of your day. Take care and goodbye.